It is my great pleasure to introduce John Fisher and Joe O'Connor to the show. Welcome to the show, guys.
Thank you.
Thank you.
Joe, tell our audience a little bit about your firm. What type of law do you practice?
Sure. Our firm is in Kingston, New York. We practice throughout New York State. The type of matters we handle are construction site accidents, motor vehicle accidents, motorcycle accidents, and what we would call premises liability accidents. Accidents where someone is injured due to a defect on someone's property.
Right.
They're mainly the type of matters that we handle at our firm.
And generally, you always represent the individuals.
We always represent the injured persons.
Okay.
We don't represent insurance companies. We don't represent defendants. We represent persons who are injured and sometimes catastrophically injured people.
Yeah, and I do want to make known to the public that your firms, when you take on a case, that you do so on a contingency basis. The client doesn't have to pay any money. If you win the case for the client, then you get paid. If you don't, then you're out. So you really evaluate cases very carefully before you take them on, right?
Certainly.
Today we are here talking about the Jaylene Munoz case. And would you tell our audience a little bit about who Jaylene is?
We got a call, my partner and I, Al Minetti, one night from Jaylene's mom, Kenitra. She said she had hired a law firm. She wasn't happy with what was going on. She had a very severely brain-injured daughter who was injured in a motor vehicle accident. We met Jaylene for the first time that night. We went to her house immediately, both my partner and I, and we saw a little girl who was all smiles, but was obviously brain injured. She had a helmet on, little flowers attached to the helmet, and from that moment on, we dug into that case because it was such a wonderful person who had been so seriously and traumatically injured.
What happened to Jaylene medically?
Well, Jaylene was a backseat passenger in a vehicle,
Yeah.
and she had a bleed in her brain called a subarachnoid hemorrhage. The right part of her skull was shattered, and she was in the worst of worst situations. She had an emergency operation on her skull on the same day of the operation, and
Right.
she had a long rehabilitation period where she was sort of like a stroke victim. She had to learn how to walk. She wore a helmet on her head, and it was about a year before she could have any normalcy at all to her life.
Tell us a little bit about why this case was unique and who the defendants were.
Well, I guess in the beginning when we took on the case, we received an accident report, as we do in all cases, and it lists one defendant driver, the person who rear-ended our client's vehicle. As the case developed, what we did, and I think it was a step we took that maybe the other firm didn't look into, we went into the DMV records and found that the vehicle was owned by a person who had substantial insurance coverage herself. So we proceeded to put the case in suit, start depositions, question anyone and everybody who was involved or saw the accident. It came about that we determined that the driver was working for a union, the SEIU,
Which is?
one of the biggest unions in the world, certainly one of the biggest in the United States.
Which is the Service Employees.
International union,
Right.
yes. And there was a dispute during the litigation as to whether that person was in his employment, and that really became the battle of the entire case.
And how did you find out that they were in their employment? In other words, when they were driving their car, they were working in the capacity of their job. How did you find that out?
During the deposition, there were some vague comments that the defendant, Mr. Nembard in this case, had come from a barbecue involving the recruitment of union persons.
Yes.
It was unclear. He wasn't quite specific. After that, I think the case was really established once John and myself and our investigative team were able to get to the persons who were at that barbecue. And that involved traveling extensively into Connecticut and tracking down all of these persons, most of them who were not legally in the country and were of Haitian descent, into their communities, getting these people to speak to us and getting these people to give us sworn statements as to the fact that Mr. Nembard was there.
Now, there were 3 missing documents, weren't there, Joe?
The missing documents
That were significant.
Well, there was some discovery that we thought should have been turned over.
Okay.
And when we're referring to, there was a report from the SEIU about the dangers of driving and driving late and late hours. We were able to obtain that after months and months of interviews of union persons. There's a union that represented the union, And eventually we found a safety person who wrote an extensive article on behalf of, who was hired by the SEIU, and it detailed exactly the understanding that they knew their union organizers were putting people at risk because of their hours.
And putting them at risk, they used to require them to drive how many miles?
There was no requirement of how much they had to drive, but they were required to use their own vehicles. They were required to use them if it was within 1,000 miles of their local base.
Right.
They were required to attend these events late at night. They were required to work through weekends and 7 days straight every other week. The extensive information that we found out about the union went much beyond that. That this was not only was it appropriate, which was one of the defenses, he shouldn't have been at a barbecue. It was appropriate, but that they asked these union organizers to go much above and beyond that type of behavior in attempting to unionize these organizations.
By the way, as a result of this case, the union can no longer require their representatives to drive more than what? They work more than 8 hours a day.
Well, that's what they were trying to do. Here's the interesting part of this. There had been an occupational hazard report that was issued the same month of the car accident in May of 2008 that stated that the union organizers at this union were exceeding all the allowable driving hours in their job, and that they should be limited in the number of hours per day that they're allowed to drive. Now, that report was ignored. It was never implemented. Any of the policies that were recommended were totally ignored. So the union's hiring an occupational hazard but ignoring the report that they had. And that's what this case was really about, a union that was putting its own workers in safety while ostensibly acting in favor of protecting the rights of workers.
Okay. Now, there was also a dispute on the life care plan amount of money. Is that right?
There was a dispute. I think both.
And explain for our audience what that means.
The life care plan projects the life care costs over
of the injured person.
Over our injured person, who was 2 years old at the time of the accident, over her lifetime. It projects also to the extent there was also a projection of lost income. The issue here, both experts, both the expert the union hired and our expert, said it would be significant. Our life care plan, the projections were very close to $70 million of medical treatment over her lifetime.
By the way, we're showing these plans as you're talking.
Their expert, her plan was probably closer to $20 or $30 million.
Substantially less.
But substantially less, and we didn't think they could justify it. Jaylene is someone who is going to need treatment and will never be able to live independently for the rest of her life.
What were some of the flaws in the union's projection of a life care plan?
The flaws of the plan were basically they were projecting in current day, present day numbers. So in other words, they're saying currently it will cost about $5 million to take care of this child for the rest of her life. They didn't project the future increase in cost of medical expenses, the impact of inflation, any of that. When you add all that stuff in, it brings it to about $20 to $30 million.
Right. Now, you settled the case for?
$7 million.
Okay.
So that number was one of the biggest recoveries, certainly in the Hudson Valley. And it came when the original offer to settle this case before we were involved was $25,000 or $50,000. It's unclear. That was made to Jaylene and her mom before they made that phone call.
And this is one of the reasons why we do these stories, is because when you do the right kind of homework, when you really pursue the interest of your clients, you can try to get as much justice in terms of dollars and cents to take care of this young lady for the rest of her life, which is what's needed, right?
Yeah, I think what really had to be done in this case, and more than any other case I've handled, we had to get witnesses that were not willing to cooperate. We talked about the persons who were at the barbecue who would confirm that this was union activity.
Yes.
Not only that, I know John and myself, we went to Connecticut at least 12 times between us. We did depositions and questioned persons in Ohio. John flew to the West Coast and met with this person who wrote the occupational report. He also went to Washington, D.C. and met with a former vice president, someone who's retired from the SEIU, and got that person to cooperate against all opposition from the union. And those efforts to go to get these witnesses, to go, in fact, we went to Florida to meet with another person who was an SEIU employee. That's what got the $7 million. Those efforts to get those witnesses and then get them to cooperate, especially the persons of Haitian descent
Right.
were not willing to talk about union, or they were even involved in union
Yeah,
activities.
they didn't want to lose their jobs. They didn't want to be retaliated
Correct.
against. Well, congratulations on this successful settlement. That's a substantial amount of money and far more than what the other law firm would have been able to get for them.